you heard there from former President Trump at the very end of the court proceedings today. They'll pick up tomorrow again at 9:30, and they'll be off for the weekend. We've been relying so extensively on legal analyst Neama Rahmani's insight, expertise to help us make sense of each of these days' proceedings. He's going to join us yet again right now. He joins me. Neama, good to see you. Thanks for being with us yet again. So you heard there from Trump. Before we get into the legal nitty-gritty, and, you know, obviously, I'm not a lawyer, and this isn't your cup of tea, but many are commenting on how he appeared, how he sounded, how he looked, just from any defendant, let alone a 77-year-old defendant who's a Republican presidential nominee. He looked somewhat exhausted. I don't want to say defeated, but this is really tiring, is it not?
Oh, it's very tiring, Andrew, to be in court all day, every day. I mean, it's physically tiring. It's emotionally tiring. It's not easy. And even if you're a lawyer, and of course, Trump is sitting there and he has to watch the whole proceedings unfold. And I'm sure he has to do work around the clock as related to his presidential campaign and other duties that he has. So this is a full-time job on top of his full-time job. So I'm not surprised that he's fatigued.
You know, let's get into the testimony itself. Day 3 there on the stand for David Pecker. I want to put this tweet up here from our friend Fox's Linda Schmidt. We spoke with her in the last hour. She tweeted this, and I think it's maybe speaks to what the prosecution is trying to get at, Neama. She said, David Pecker says the payments to Stormy Daniels and Karen McDougal were not to protect Trump's family, but rather to protect his run for president. Pecker said it was basically, quote, what the impact would be to the campaign into the election. Is that a slam dunk for the prosecution? Can they wrap this up and go home? Is that all they need? That's what they're trying to prove, right?
That is what they're trying to prove, Andrew, but I don't think it's anywhere near a slam dunk. Obviously, we know that Pecker has been subject to cross-examination, and that was a helpful statement, no question, for the district attorney's office. But he also said that Michael Cohen had nothing to do with the presidential campaign. So there was some testimony both ways. And of course, we know that the prosecution is trying to prove that these payments and business records related there too were related to the campaign. So that's why that testimony was helpful. But I don't think we're anywhere in the clear yet if you're the state or the district attorney's office.
All right, let's go over just more of the Pecker testimony as well. He testified that Trump's family was never mentioned in these conversations with both Trump and Michael Cohen. So Pecker made that assumption that we just read out to you. So it's just clearly an assumption. He thought, presumably, Trump really cares about the outcome of the 2016 presidential campaign, but they were somewhat trying to get at that, you know, he didn't necessarily care how this would impact his family, his children, his wife Melania, just that it would impact the campaign. Was that the line of argumentation, and was that fair?
Well, it's hard because, you know, you're really trying to get into Donald Trump's head, and there's really direct evidence of what he was thinking. If he were to say, I am doing this because I want to be president, or I am doing this because I want to save my wife and children from embarrassment. We don't have any of that direct evidence, right? So now you're talking about circumstantial evidence. Circumstantial evidence is allowed to be presented. So circumstantial evidence would, of course, be if Trump is only talking about Stormy Daniels and Karen McDougal in relation to the presidential campaign. The inference would be that he cares, and the reason he's doing everything, whether it's the payments or the business records, for that purpose. But again, I don't think it's a smoking gun that people are making it out to be, even though it is helpful.
I mean, maybe the reason, I don't want to like kind of psychoanalyze Trump or whatever, but maybe the reason he looked so tired, somewhat dejected, was that all of these details, very personal details, were just kind of laid out in the public record there in court. Pecker confirmed he spoke with Trump November the 5th, 2016. He said he received a text from Michael Cohen saying, quote, the boss wants to speak with me. Pecker says Trump was very upset, saying, how could this happen? I thought you had this under control. Either you or one of your people leaked this story. Now, that was the story in the Wall Street Journal about Karen McDougal. Karen McDougal has really faced so much of the questioning back and forth. She's really been front and center, even while not being present in the courtroom here. What's the point of that? What's the prosecution trying to establish by bringing up Karen McDougal even before Stormy Daniels?
Well, it's really that pattern in practice, right? And obviously a very different case, but, you know, Harvey Weinstein's conviction was overturned today, and what the appeals court there in New York said that, well, you can't bring in these other witnesses of pattern and practice prior bad acts. But that's what the state is trying to do here, and just say, listen, this was Donald Trump's MO when he's dealing with the Inquirer and these catch and kill stories. We make the payment. It wasn't a non-disclosure agreement. We make the payment, and we want to mislead the American people. So, sometimes jurors may have a tough time believing one witness, but if another witness comes and tells a very similar story, and obviously we don't know if Karen McDougal is going to testify at all, but to the extent that all this evidence is coming in related to her, it does support the prosecution's case because this is a consistent pattern on the part of the former president.
You and I had talked about whether or not the Access Hollywood tape would be admissible. It's not admissible, but a transcript of the tape was discussed today there in court. Were you surprised by that? And is that just more ammunition for the prosecution to kind of lay the foundation of what they're trying to prove?
I was surprised. I understand the relationship to Karen McDougal and the charges in this case, but I do believe the Access Hollywood tape, that really is a bridge too far, possibly unduly prejudicial. And you're right, Andrew, this is all very embarrassing for Donald Trump. And his family is not there in the courtroom to support him. I think that they probably, especially Melania, wants nothing to do with any of this. I mean, if these allegations are true, setting aside the criminal consequences, I mean, we're talking about someone whose husband engaged allegedly in an extramarital affair.
Engaged in two allegedly extramarital affairs. Yeah. I want to talk about this because we got an inside look into how this world operates with very high-profile people and kind of tawdry tabloids, of course, David Pecker being the former publisher of the National Enquirer. And so you kind of got this inside look into how the catch-and-kill operation works, so to speak, how it gets off the ground, who speaks to who. And even Pecker said this today, that he visited the White House in July of 2017, and that was seen as some type of, intangible reward for catching and killing these stories by McDougal and by Daniels here. So that was, I thought, fascinating. There's been a lot of reporting on it. There's been a lot of books written on it. But to the outside viewer, to these upper echelons of power in New York City media, we really didn't have a vantage point into that process. And now we do, don't we?
Oh, we do. And this is something that even casual observers, you might not really care about this trial one way or the other, but when you see tabloids that are getting involved in paying off folks so you don't report the news, and it's not just Donald Trump, right? And it's not just Stormy Daniels and Karen McDougal. We're talking about Tiger Woods. We're talking about Mark Wahlberg. We're talking about Rahm Emanuel. These are all individuals who allegedly had unflattering stories about them that never hit the media or the public because payments were made.
All right, let's talk about what's next here. Do you think, and I asked you this at the outset of Pecker's testimony, what about now? Has he been helpful? Has he been reliable? Do you think he was a good witness to call here? On the third day of his testimony, is he providing value?
He is providing value because he's really sort of setting the scene. Like I said, I think there's some issues with his testimony. There's been some inconsistencies that came out today regarding some of the dates that he testified to previously and he reported about. So his credibility was hurt a little bit there. Obviously, the grant of immunity, that's not really helpful. He did make that statement that distanced Michael Cohen from the campaign as well. So overall, I would say he's a good witness for the prosecution, but we still have to see how the rest of the cross-examination goes. His credibility may be chipped away further tomorrow. And then it's a question of if he does get beat up, metaphorically on cross, was it the right decision to put him first?
I see. All right. Neama, what about the gag order question? When are we going to get an answer on that? The next hearing is going to be next Wednesday when court's off here. Why haven't we gotten an answer yet?
We haven't gotten an answer because I think Judge Juan Merchan is going to issue a written order because he knows that almost certainly it will be appealed. Trump has a pretty good First Amendment argument, and he has tended to appeal every adverse ruling against him, both for procedural reasons to delay things, but also substantive ones. And apparently there were 4 more violations. And I think really the question isn't, did Trump violate the order, but what sort of sanctions is Judge Merchan going to impose? Are we talking about $1,000 for each violation, or something more substantive, potentially even an adverse jury instruction, which would be very damaging if the judge instructed the jurors that Donald Trump violated a court order.
So if that was the case, how does that sway a jury? I mean, does a jury keep that in the back of their mind throughout the duration of this trial? Do they use that when they deliberate? I mean, it almost seems like we have this side trial going on with all of the gag order updates, and it's kind of been a sideshow of all of it, but it's important.
Well, it's very important because you're talking about someone's First Amendment rights and how they conflict with a right to a fair trial, and witnesses not being intimidated, or they're not being obstruction of justice. So we're really in uncharted legal waters in so many ways with respect to Donald Trump. Obviously, the Supreme Court dealt with presidential immunity today, but also this is First Amendment issue. We're in the middle of a presidential election, and to what extent should Donald Trump be barred from talking about the parties and the witnesses in this case?
Yeah, Neama, we were originally going to speak on the immunity question at the Supreme Court, but we've been talking about this particular trial all week, so we wanted to stay with that. But there is a tie-in, because Trump's legal team tried to use the immunity argument in this very case, and it was struck down here. So they have been kind of putting out all the stops on the immunity question, not only there in Jack Smith's federal D.C. case, in Georgia, and here as well, but they didn't get success here, did they, on that question?
They did not. And Trump's team, even if they lose before the Supreme Court, they've done a masterful job using the presidential immunity argument to delay the D.C. election fraud case, the Georgia election fraud case, and the classified documents case. Obviously, in this case, Trump was not president at the time of the conduct, so none of the immunity arguments apply. He was just a candidate. So that's why this trial is going forward, while the other three are more or less on hold, pending the Supreme Court's decision, which will probably get at the end of its term in late June or July.
Yeah, we've been, talking extensively with legal analysts like yourself on what I think for constitutional scholars is kind of a pretty fascinating question. What are the limits of presidential power? And so we're going to continue to do that. Like you said, we should get a ruling on that question, sometime in June. And your thought on that, though, lastly, I mean, whatever they decide, is it going to put that question to bed, do you think, or no?
I don't think so, and this is why. I think Chief Justice Roberts made it clear that the D.C. Circuit, they should have addressed whether Trump's conduct were official acts. Because obviously we know if they're official acts, they would be subject to presidential immunity. And if they're personal, they're not. But what the D.C. Circuit did was they said, well, Trump's a former president, so presidential immunity doesn't apply at all. I think they got it wrong there. I also think that Trump's lawyers got it wrong when they said he's absolutely immune. The legal standard is clear. There is immunity for official acts, but really a lower court, needs to decide whether the fake elector scheme or the events leading up to January 6th and the Capitol riots, were they official acts or personal ones. So I think they're going to kick it back down to the lower courts with some guidance that will probably delay this issue even further.
All right, Neama Rahmani, as always, can't thank you enough. Talk soon.
Of course. Thanks, Andrew.